All rise. The appeal in the name of Loveridge and Loveridge.
Yes, Mr. Ashford.
Good morning, my lord, my lady. In this matter, I appear on behalf of the appellants, Ivy and Aldy Loveridge, along with Mr. Dan McCourt-Fritz. The respondent, Michael Loveridge, is represented by Mr. Mark Anderson, Queen's Counsel, and David Stocking. My lords, we have spoken about timetabling of this matter, and I plan to deal, subject of course, when the court says the contrary, with the company's petition appeal first.
Yes.
With Mr. Anderson responding to that. The proposed timings for this are clearly subject to judicial intervention, or that I should speak until about 12:15. My learned friend will then have from 12:15 till 1 and 2 till 3. I will then reply between 3 and 3:15, and then Mr. McCourt-Fritz will address the court on the committal costs appeal at 3 o'clock. That's right, 3:15, and we anticipate that will take it to the close of the day.
Yes. I'm sure you're right that we should look at the petition amendment appeal first before the costs appeal. If we go down the route you say, you'll all have to stick very closely to the timetable. We'll see how we go.
Thank you, my lord. I'll obviously do my best.
Yes.
My lords, my lady, I've handed up a table.
Yes.
Which may just assist as to the various respondents, the directorships of each of the respondents, the legal shareholders and the beneficial shareholders, the only difference being in Breton, whether the companies are creditors or debtors, as between themselves, and the pleaded complaints in respect of each of the respondents, sorry, each of the companies. And I've added on to the bottom there Far Forest, which is the company which is not party to the petition, the one solely owned by Michael, but in respect to which he and his mother Ivy are both directors.
When you say that Ivy is the sole beneficial shareholder of Breton Park, is that in dispute?
Yes, my lord, it is absolutely in dispute. We'll come on to Breton Park.
So we should put a question mark by that. Are all the other shareholdings undisputed?
They are, my lord, yes.
That's your case, is that Ivy is the sole beneficial shareholder, but it's not accepted by Michael.
Nor is it indeed accepted by Aldy, or indeed Aldy's wife.
Right.
And I'll come on to that in due course. Aldy being in the process of divorce proceedings from his wife. We appeal, with permission of this court, against paragraphs 1 and 3 of the order of His Honour Judge Cooke, which is in the core bundle at tab 23 at page 219. By paragraph 1, the judge permitted Michael to amend his petition in the form of the draft attached to that order, which is the version that one sees at tab 27, page 237 onwards. And by paragraph 3 of the order, the judge injuncted the appellants from taking any action to demand repayment of or otherwise enforce certain loans. We'll come on to the loans in due course. As this court emphasised when the matter was last before this court last year, it's necessary to consider each of the 5 companies to which Michael's petition relates separately and to distinguish between them insofar as there are relevant differences between them. And the Court of Appeal's judgment is in the supplemental bundle. I assume your Lordship's relationship have read the Court of Appeal judgment. I will come back to it as and when we need to. We say, my lord, my lady, that time and again the learned judge failed to draw the necessary and appropriate distinctions between the 5 companies. And that recurring error informs the proposed structure of the way I'm going to address the court. I intend to start by addressing R5, Breton Park, which is one aspect of ground 1C of our grounds of appeal. It's a special case because, as we will show, even if Michael's new unfair prejudice complaint in relation to the intercompany loans is maintainable, which we say it's not, there is no pleaded allegation that the affairs of Breton Park are being conducted in a manner which is unfairly prejudicial to his interests as a shareholder, if he is a shareholder of that company. We say it follows on any view the petition in respect to Breton Park must be struck out. I will then address the position of the fourth respondent, Kingsford, which is the other aspect of ground 1C. And that's a special case for different reasons. It is the company in respect of which the appellants have made an offer to purchase Michael's shares. They did so by a letter dated 30th of October 2020, which I hope has found it into your bundles in the supplemental bundle at tab 16. Thank you, my lord. The judge held that offer, which is referred to as the Kingsford offer, as not being a valid O'Neill and Phillips offer. But for the reasons that we will explain, we submit he was wrong to do so. By accepting the Kingsford offer, which has remained open throughout and still remains open, Michael would obtain exactly the outcome that he seeks by his petition in respect of Kingsford. The Kingsford offer therefore satisfies the O'Neill and Phillips requirements, and that's true irrespective of whether Michael's complaint regarding the intercompany loans is maintainable. Accordingly, his continued pursuit of this petition in respect of Kingsford constitutes an abuse of the court's process and should have been struck out and should now be struck out by this court. We say that those first 2 points dispose of the petition completely in respect of Breton and Breton Park and Kingsford. I'll then turn on, when I've addressed you on those matters, to deal with what remains. First is the exclusion from management, which is ground 1A. Here again, the importance of distinguishing between the companies is reinforced. There is no allegation of exclusion from management in respect of Breton Park, nor could there be. Michael is not and never has been a director of Breton Park. He's not a de jure director. It's never been alleged he was a de facto director. Nor could there be an allegation of exclusion from management of R6, the sixth respondent, Quatford. Because Quatford is a 50-50 company, co-owned by Michael and Ivy in equal shares. They are also the only directors of Quatford and its subsidiaries, which are not, those subsidiaries are not party to these proceedings. Michael is in de facto exclusive control of Quatford and its subsidiaries. So there's no question of him being excluded from management of that company. As regards beauty sales or sales, this court held first time round that the exclusion of him from management could not have constituted unfairly prejudicial conduct, given Michael's unlawful misappropriation of the £1.25 million from the company. We say that that unlawful conduct, compounded by his failure to recognise its unlawfulness, was so serious that it justified his removal as a director of Kingsford and would have justified his removal as a director of Riverside Partnership, although he hasn't in fact been removed as a director of that company. But there is a more fundamental point, which is that despite the guidance given by this court the first time round, Michael has failed to plead a maintainable entitlement to participate in the management of any of the respondent companies, so his exclusion complaint does not get off the ground. I will then turn to the question of intercompany loans, which is ground 1B. That is the new and unheralded complaint by Michael that it was somehow unfairly prejudiced his interests as a shareholder in the respondent companies for sales in Kingsford to demand and enforce the loans that they made to Quatford, Riverside Starport, and to his own company, Far Forest, which is wholly owned by him. The loans to Far Forest total £1.28 million. The learned judge held that the pleaded complaint had a real prospect of success. We say that he was wrong to do so. He should have held it was unarguable that the actual or contemplated enforcement of loans on behalf of creditor companies could amount to conducting the affairs of debtor companies for the purpose of an unfair prejudice complaint by Michael as a minority shareholder in the debtor companies. He also should have held that there could not be equitable constraints precluding the enforcement of loans, which was common ground were repayable on demand, a fortiori as regards the loans to Far Forest. And Lady Justice Andrews, when granting admission, said these aspects of the case raised issues of law which are potentially of wider importance. And finally, I will turn to the interim injunction, which is ground 2 of our appeal. Of course, if the complaint with the intercompany loans is not maintainable, there's no serious issue to be tried and the injunctions fall away. But even if the judge was right to permit the amendment to introduce the underlying complaint, which we say he wasn't, the injunction should be set aside because he failed to consider the adequacy of damages or other monetary compensation. Michael has failed to evidence, let alone establish, that monetary compensation would be an inadequate remedy if the injunction were not granted but he succeeded at trial. And thirdly, the injunction, if left undisturbed, risks causing loss to the creditor companies, Kingsford and Beauty Sales, which could not be adequately compensated in damages, not least because they are not entitled to enforce the cross-undertaking which is given by Michael to Ivy and Aldi. So with that introduction, may I turn please to Bretton Park. We deal with this briefly in our skeleton at tab 21 at page 198 at paragraph 83. The legal ownership of the shares is 50-50 between Ivy and Michael. The beneficial ownership of the shares is, as your lordship has pointed out, disputed. Ivy says they belong to her. Michael says they're held 50-50. Audi's wife, the third respondent, and Audi being the third respondent to the petition, has made a claim to the shares in the divorce proceedings and is seeking an order under section 37 of the Matrimonial Causes Act that they be retransferred to Audi. Ivy has put in evidence in that case, in the matrimonial proceedings, setting out why she says they're hers. Michael has been ordered to, but to the best of our knowledge has failed to advance any case in the Matrimonial Causes Act as to why they are his shares, or he's entitled to.
Sorry, can I just clarify? Is the allegation in the divorce proceedings that all the shares are owned beneficially by Audi?
In Bretton Park, yes, my lady. So the shares in Bretton Park were retransferred, or transferred to Ivy and Michael from Audi's name in, I think it was July 2019 or thereabouts. So there's a section 37 under the Matrimonial Causes Act application to reverse that transfer, effectively to put them back into Audi's estate for the purpose of the divorce, which the wife is then claiming.
And section 37 is the one that allows you to undo transactions intended to frustrate.
It's a section 423 of the Insolvency Act, but without the transaction under value.
Yes.
It's a putting assets out of your
reach
of your
spouse.
That's right. So Ivy's put evidence in that. Michael has been ordered to, but hasn't put any evidence in that. Now, nothing actually turns on that dispute for the purpose of this present appeal, but it's right that this court should know about that. The directors of Bretton Park are Ivy and Audi. Michael is not, has never been a director of that company. Now, the Court of Appeal judgment, which is in the supplemental bundle at tab 14, page 302, Lord Justice Floyd, with whom Lord Justice Lewison and Lady Justice Aspin agreed, said at paragraph 53, there is, however, a second remarkable feature of the petition in the present case. As I've said, a petition under section 994 must show there is something in the conduct of the affairs of the company which is prejudicial to the interests of the petition of the shareholder, and the prejudice is unfair. Apart from the attempts, in one case unsuccessful, to change the accountants, in the case of the three of the companies concerned, Bretton Park, Watford and Riverside Starport, there's no allegation at all of anything done by the majority which consists of the conduct of the affairs of the company. Against that background, it's then necessary to look at what the amended petition says about Bretton Park, which merits only 4 mentions in the entire petition. The petition is at tab 27 in the core bundle, starting at page 237. At page...
Sorry, Mr. Ashworth, which page?
Paragraph 36 on page 243, my lord. there's a mention of the dispute as to the ownership of the shares in Bretton Park, which claim is said to be false. At paragraph 44, we have the details of the incorporation in the case of Bretton Park in July 2014. In paragraph 77, which is part of the new pleading, there's reference to the incorporation and then how that acquisition was funded. And at paragraph 104, there is a pleading at 104 sub 6 that there's deadlock in Bretton Park. There is actually no deadlock at board level because, of course, Michael is not a director. Ivy and Audie are. The amended petition thus makes no complaint and alleges no conduct in relation to the Bretton Park loan, nor does it complain or allege conduct in relation to any exclusion from managing Bretton Park. There is a generic exclusion, a complaint of exclusion from management at paragraph 91. In the case of Kingsford and any other respondent accepts sales, such exclusion is unfairly prejudicial to his interests. And at paragraph 99, where there is a generic reference to the petition's exclusion from management. But no particulars are given in relation to Bretton Park. Given Lord Justice Floyd's conclusion at paragraph 53, how the parties could ever have understood Michael to be entitled to participate in management cries out for an explanation in the amended petition. There is none there. Without any explanation at all, it is impossible to infer such an understanding. Michael has never explained this aspect of his case, either in his various versions of his pleadings or in any evidence. The judge did not consider the distinct position of Bretton Park at all. Had he done so, he would have been bound to hold that Michael's bare assertion of an entitlement to participate in management, if there is in fact such an assertion, was unarguable, even if the equivalent allegations in relation to any of the other corporate respondents were maintainable, which they are not. But none of the amendments remotely displace Lord Justice Floyd's conclusion regarding Bretton Park. And the judge dealt with this in his judgment at paragraph 45 at page 229. The remaining pleading Havishers, in my view, an arguable case in respect to sales by virtue of his interest in the loans it made, in respect of Bretton Park, Croft and Riverside, Bewdley, by virtue of exclusion or threatened exclusion from management, and implied threat of withdrawal funding of beneficial funding. But there were no allegations to which that finding could attach. Now, what is said by my learned friend in their skeleton argument is at page 205 of the bundle. Paragraph 15. Where it's asserted that there was clear evidence before the judge that Michael had been excluded from the management, and that evidence was brought to the judge's attention. There was no evidence before the court at all on this topic, let alone anything that was brought to the judge's attention. And then we have a fairly remarkable last sentence. We acknowledge that this has not found its way into the amended petition with clarity. It hasn't found its way into the amended petition at all. let alone with clarity. The judge, and it's remarkable that in light of what Lord Justice Floyd had said and the lesson that had been given on how to plead an unfair prejudice petition, that you can have a pleading which doesn't find its, or an allegation which doesn't find its way into an amended petition with clarity. So we say the judge should therefore have struck out Michael's petition in respect to Bretton Park for the simple reason that no allegation of unfairly prejudicial conduct was pleaded in relation to that company. And we therefore respectfully invite this court now to do so.
As I understand it, you're making 2 points. One is it's not there in the amended petition, but in any event, Michael was never a director of Bretton Park, so he can't complain that he's not a director.
That's right. I mean, my lord,
that's a substantive point, not just a pleading point.
Yes, that's right, my lord. Of course, it could be excluded from management without being a director, but he hasn't alleged a case that he was involved in the management of the company either. So one doesn't have, it'd be wrong to say you have to be, it's director or no director.
Yes, I can see that.
So, by the way, yes, it is both a pleading point and a substantive point.
But he does allege, at paragraph 82, that he was entitled to participate in the management of all aspects of business. But that's part of a sort of global allegation.
My lord, yes. It remains his case that he was driving force. He wasn't at the very least entitled to participate in the management of all aspects of the business. Now, what the Court of Appeal said in respect of that is not sufficient.
The driving force fallacy is not enough.
But it goes further than that, my lord, because driving... sorry, I ought to take you... I was going to come back to it later on, but can I take your lordship to what he said in respect of the driving force fallacy? It's paragraph 51, my lord, of his judgment. It says I coined the phrase. In fact, I have to say my junior, rather more cleverly than I, coined the phrase, the driving force fallacy.
Yeah.
But the fact an individual played an important, even a leading part in the development of a company's business does not entitle him as of right to special treatment under the company's constitution. I agree that the fact an individual has had such roles not sufficient that he's entitled to maintain it in the face of constitutional rules which permit it to be terminated. And then, sorry, I should have taken paragraph 50 above as well, my lord. Halfway through the paragraph, his lordship said, it's not the law that progressive and energetic managers, however well they perform their duties to benefit the company, acquire entrenched rights not to be removed from their positions if the constitution of the company permits their removal.
Yeah.
So, my lord, there is nothing more. And of course, at this stage, and I'll come back to it in respect of other companies, but at this stage, there was a pleading before the court, which is cited in paragraph 48, that he was entitled, he had a right to be involved in the management as well. So it wasn't just I had the right to be in sole control. The Court of Appeal were considering an amended petition which said I have the right to be involved. And their lordship said that's not enough. That doesn't work. May I move on to the Kingsford offer, or is there anything else arising in respect of Bretton Park? The Kingsford offer is at the back of the supplemental bundle, at tab 16. And from earlier observations, I take it that you have each had an opportunity of reading this.
Yes.
Those who have practiced in this area will be familiar with this sort of letter because it's an O'Neill and Phillips offer. And in the...
I'm sorry, Mr. Ashef, where do we find it?
Sorry, tab 16 of the supplemental bundle at page 310, my lord. It might be useful at the same time to have out O'Neill and Phillips in the bigger bundle of authorities at tab 7. This is 1999, One Weekly Law Reports at page 1092. Lord Hoffman gave the judgment of the judgment which other lordships agreed. And at page 1108, 7, he dealt with the question of making an offer. And if I can invite your lordships and ladyship to start at letter C, if the respondent to petition has plainly made a reasonable offer. And invite you to read down to 1108, letter C. His Honour Judge Cooke dealt with the Kingsford offer at paragraph 47 to 54 of his judgment in the core bundle at tab 24, page 229 to 230. And he held at paragraphs 52 to 54, well, the only reason given by the judge on this as to why it wasn't sufficient was that Michael's complaints as to intercompany loans was that the only reason why this Kingsford offer didn't work. Now, the offer itself was made on the 30th of October 2020. The complaints about the loans amounted to unfair prejudice were raised for the first time on the 4th of November with a promise of a further version of the draft amended petition, because there had been a petition which had made no mention of this. And that came on the 16th or 17th of November. So effectively, the judge, in granting permission for that amended petition, or part of that amended petition, defeated the Kingsford offer. But even so, he was wrong to do so. In the respondent's notice, Michael seeks to resuscitate a point. It's a paragraph, it's page 169 to 170 of the bundle. It's bottom page 169. The offer to buy the petitioner's shares in Kingsford did not remedy the unfair prejudice to the petitioner as a shareholder in the company because, and there are 3 points made in the respondent's notice. Offer wasn't expressed to remain open for a reasonable time after the hearing. It was an offer to acquire the shares at fair market value, which was the wrong basis of valuation. The market value of the company was relevant, not the market value of the petitioner's shares, not remedied by proposed to be no minority discount. Significant risks of value when asked to find the market value of minority shareholding would have decided to be negligible without needing to apply a minority discount. And the third was the not bringing the offer to an end. His Lordship dealt with this and rightly rejected that at paragraph 50 of the judgment at page 230. And the judge was obviously correct there being no material distinction between fair value with and fair market value with no minority discount to be applied. And if one looks at the terms of the letter itself, at page 310, paragraph 1, purchase at fair market value, paragraph 2, the value will not be subject to a minority discount. And that, of course, accords with what Lord Hoffman said in O'Neill and Phillips, that there should be a fair value without a minority discount. One will also note, my lords and my lady, at the page 311, at the end of the letter, we said, should you consider any element of the offer made by the debtor fails to comply with the prescribed requirements for an O'Neill and Phillips offer, you're inviting to confirm this, identifying your reason within 14 days. If you fail to identify an alleged defect, we will submit you are stopped. This point was just taken at the hearing. Nothing was put in writing at all. And in any event, we made it quite clear at the hearing, and the references at page 264 in the supplemental bundle at letter F of the transcript. I don't intend to take you there, but I give it for your reference, that we were quite happy to restate the offer with the word market deleted, if that really was a material change. For those three reasons, there is nothing in the respondent's notice point. So if the appeal on the loans complaint succeeds, the petition in respect of Kingsford must be struck out because the Kingsford offer renders its pursuit an abuse of the court's process. But even if the complaint in respect of the loans is maintainable, which we say it's not, the petition should nevertheless be struck out because accepting the Kingsford offer would provide Michael with all that he seeks by way of final relief. If one turns to the amended petition at page 257 to paragraph 101, you will see what the remedy sought is in respect of remedying the alleged unfairness. First and second respondents, or the fourth or eighth, should between them acquire the petitioner shares of the fourth to eighth respondents, and of course Kingsford is the fourth respondent here, at a fair value being the undiscounted proportion of his shareholdings of the market value of the company in question as a going concern. Nothing to do with the loans. There's nothing in respect of that. And in any event, the judge himself ruled that by accepting the Kingsford offer, that would place Michael in the same position as sought by paragraph 101 of the amended petition, and indeed subparagraph 4 of the prayer.
Where's that in the judgment?
It's in the supplemental ruling, which is at tab 29, which is an exchange of emails between the parties and the judge. The judge had said at the end of his judgment, here's my ruling, go away and put together the amended petition in accordance with my ruling. And a draft was prepared. And might I hand up to your lordship's relationship a copy of paragraph 101 as it stood at the time of the submission to the judge. So what happens in this correspondence at page 296 of the call bundle, Mr. Stockwell writes to the clerk, to the judge, he having directed the petition be served by 4 p.m. that day, setting out the areas of dispute between the parties on the amended petition, and it included, as submitted with this email, paragraph 101 in this form. There was a dispute on paragraph 101, as is evidenced by page 297, paragraph 5 of the email, and Mr. McCourt Fritz's response at page 295. And that led the judge to rule, at page 294, Para 101, I did rule the argument for an uplift of value to represent assumed continuation of management by Michael was unsustainable. The same goes for the other adjustments pleaded. This para should end after as a going concern, which your lordships and ladyship will see is halfway through line 5. So deleting, valued on the assumption that its future performance will be unaffected by his exclusion from management and the less competent management of the first two respondents, and adjusted to compensate the petitioner for the loss of the indirect benefits associated with interest-free indefinite loans to Far Forest, Watford and Stowpole. Mr. Anderson at page 29, bottom of page 293, top of page 294, queried this with the judge, just in respect to paragraph 101. The words which the judge proposes to disallow contempt for 2 adjustments, an adjustment for the loss of Mike's employee, it's been disallowed, we have no more to say about it, an adjustment for the loss of the benefit of the interest-free loan. The ruling conveyed by your latest email was would disallow the second contention. Our understanding was that the judge had ruled that contention was arguable, and it was the reason why the O'Neill and Phillips offer did not work. Back comes the judge and says at 293, my ruling was the removal of the availability of the loan was arguably unfair prejudice, and that would not arguably be cured by an offer to buy the partner out of the lending company without including the borrower company. But if there is venture in order for sale, I said I did not think there was a sustainable case for uplifting the price for effects of change of management. It seems the same to me. The same must follow for other changes that the sale would entail, such as loss of access to assets. So he directs that those bits come out. And one then says, well, then if you then go back to the Kingsford offer, what is the difference between what he said the remedy would be for unfair prejudice and what is the, between that and what is in our offer letter? And the answer is there is none. And there is no cross appeal against the judge's ruling on this to require the deletion of these additional words. So having restricted the terms of paragraph 101 to limit the requirement on us to acquire his shares at a fair value in the undiscounted proportion of his shareholding to the market value of the company in questions of going concern, he achieves precisely that result by accepting the Kingsford offer.
There were 2 other points made in the respondent's notice. One was the offer wasn't kept open.
My Lord, I'm going to turn to those.
Yes.
So we say that the pursuit of the petition is futile and abusive, even if the unfair prejudice petition complaint in respect to the loans is maintainable. Now, we say the judge's reasoning in relation to Kingsford is internally inconsistent and is unsustainable, and therefore he should have struck out the petition in respect of Kingsford in light of the offer, irrespective of the maintainability of the unfair prejudice complaint. And that would have been consistent with and supported by his own decision in Harborne Road Nominees and Kowalski, 2011 EWHC 2214 Chancery, which you will find at tab 3 of the bundle of authorities. And this was an unfair prejudice petition between equal shareholders, in which there were various other claims and counterclaims being made, where one didn't have access to all of the information. There were allegations of breach of duty about potential removal of assets out of the company beforehand. And his lordship firstly and rightly said, when one looks at the law and submissions at paragraph 24, having identified O'Neill and Phillips and set out the passage which I've taken this court to at paragraph 25, he rightly said, of course, the guidance does not have the status of legislation. It is guidance.
Sorry, which paragraph?
So paragraph 26, he says, he starts the analysis at 24, dealing with O'Neill and Phillips, and then Lord Hoffman's speech at 25, And then 26, the guidance gives considerable detail, but it does not have the status of legislation. And he commented that effectively the format had been taken out of Mr. Joffe's textbook. And then at 27, pointed out the obvious difference between this case and O'Neill and Phillips, that Mr. Morris is not a minority shareholder, but an equal 50% shareholder. He alleges the company was established and run as a Queensland partnership. And then goes on to say, Lord Hoffman's remarks are not made in this context, but expressly about cases where there is a majority shareholder. Ultimately, in breakdown of relation between majority and minority shareholder, the solution is likely to be the minority shareholder must exit the company or be offered the opportunity to do so on fair terms. And so his case there was about equality of shareholding. Here we are in Kingsford in a minority shareholders, a genuine minority shareholder in respect of Kingsford. And he sets out some potential difficulties. In paragraph 31, he says a related difficulty arises, it seems to be, where one shareholder has been excluded from information about the company and there's reason to fear that the other may have committed some breach of duty. And then in that paragraph, just above letter I, it says, if he has refused an offer and had his petition struck out, he has no remedy at all unless he can persuade the court to permit him to present another, which would not be a foregone conclusion. That's in circumstances where no access to books and there's been a suspected breach. And then he deals with the question of the no subsisting offer at paragraphs 33 to 35. And could I invite the court to read those?
Before we go on to that, you showed us Judge Cooke's judgment at 26, 27. Do you accept what he says at 27 as being a correct statement of the law?
Sorry,
in Harborne Road.
So which part of paragraph 27?
He draws a distinction between majority-minority cases and 50-50.
My lord, for the purpose of this, it doesn't matter because we are in a minority situation. Whether he's right or wrong is irrelevant for the purpose of my submissions. Because we're in a minority, we don't have a 50-50 in respect to Kingsford.
No.
It's the 1/3, 2/3. I don't think I need to say whether he's right or wrong. It's for greater minds than mine to decide that.
So then 34.
33 to 35, I invite you to.
Yes.
We say, my lord, that paragraph 34 exactly in point that when a minority shareholder is made a fair offer and he rejects it, he cannot complain he's left as a minority shareholder with all the vulnerability that entails. Doesn't mean he's forever without remedy if some further act of unfair prejudice occurs thereafter. In that respect, it's in the same position as any minority shareholder would be. He's not entitled to insist on any standing offer being made that he can accept at any time. So if one had an example of a case where after exclusion of the minority shareholder an offer had been made, which he'd rejected, for example, the majority shareholders and directors then decided that they changed the dividend policy and give themselves, or have no dividends but pay everything by way of salary, for example, and thereby excluding him, that might be a further act of unfair prejudice, which would give rise to a separate petition. So my learned friends are wrong in their skeleton argument at paragraph 54 to suggest that we effectively say that the law condemns a minority shareholder to eternal unfair prejudice if he refuses an offer before the court has ruled the offer is adequate to cure the prejudice. We don't say that at all. There is no risk of eternal unfair prejudice. That prejudice is cured if petitioner is offered a reasonable opportunity to accept a valid offer, and if he fails to do so, he only has himself to blame. There can be no principle, policy or practice that the offer only becomes effective if the court rules that the offer is adequate to cure the alleged prejudice. That would be truly absurd. You'd have to come to court to get a determination, and the whole purpose of the O'Neill and Phillips offer is to avoid going to court, to avoid this sort of litigation. You may or may not have seen in the bundle of authorities, there's an authority called Lloyd's Auto Body, which isn't referred to in the respondent's skeleton argument, but they have asked to be inserted in the bundle. I will deal with that in reply to the extent that is necessary, but I say this: it is wrong and should be overruled to the extent that it is to be interpreted as doing what Michael seeks to allege it does, which is that even when there's been, in that case, held to be a proper exclusion, there's no unfair prejudice at all, His Honour Judge Hodge went on to say, but you still can't keep him locked in as a shareholder. What he actually did was say he's entitled to be bought out with a 60% minority. And that we say, insofar as my learned friend says, that effectively says you can't lock a rightly excluded minority shareholder in, and you have still to buy his shares out. That's wrong as a matter of law. That's contrary to Lord Hoffman in O'Neill and Phillips saying you can't have a no-fault divorce in these matters.
You say this authority is not referred to in the respondent's skeleton.
It was referred to below, and they've asked for it to be put in the bundle now. So I anticipate it's going to be referred to, but I simply, as a headline, say it's wrong. And I'll come back to develop that further if my learned friends. And of course, it doesn't bind this court, it's the court of the first instance anyway. The third point was that the Kingsford offer wouldn't have brought the litigation to an end. It would have brought the petition in respect of Kingsford to an end, and therefore makes the pursuit of that petition abusive. As was accepted on behalf of Michael before the judge, the sites could be sold separately from each other. These are all companies holding separate sites that do not trade with each other. There's no intercompany trading between them. You can sell one perfectly easily. Indeed, as was pointed out by his lordship to my learned friend below, when he made the point you can't do it without selling the whole lot together, so, but aren't you trying to do exactly that in respect to one of the partnership properties, partnership sites? That they decided that they wanted to try and sell out Riverside from underneath us, but before His Honour Judge McCahill's order was overturned. So the difficulty with the submission that a valid O'Neill and Phillips offer would have to bring the entire proceedings to an end can be illustrated by considering the position if Ivy and Aldi could not afford, for example, to buy Michael out of all the companies. On Michael's case, just because they couldn't buy him out of all the companies, they'd be bound to litigate to the end all of the entire petition, even though they made a perfectly valid offer in respect of one of the companies, Kingsford. And that can't be right. And it's no less perverse if a petition, take it away from this case, imagine you have a petition in respect of two companies. In respect of Company A, the petition is hopeless, but the petition in respect of Company B is well founded. And the companies are owned by the same people, A and B. In that situation, the respondents on my learned friend's analysis couldn't make an O'Neill and Phillips offer in respect of Company B, the good claim, without also making a simultaneous offer in respect of Company A, because it wouldn't bring the litigation to an end. And one can see that if one gets to the end of the trial, and the court says there are a number of companies here, let's stick with the two companies here, and unfair prejudice is found in respect of one company, but not in respect of the other company. What would happen if, at the end of the litigation, for example, here, the court were to find unfair prejudice in respect of Kingsford, but no unfair prejudice in respect of Quatford? The court can make an order in respect of Kingsford, Ivy and Aldi to buy Michael's shares, but the court could not make an order in respect of Quatford. It would have no jurisdiction, because the jurisdiction to make an order under section 994 and 996 is only in respect of a company where there has been a finding of unfair prejudice. So you have a situation that if Michael is right about this Kingsford offer, Ivy and Aldi are bound to litigate this through because he happens to have joined 3 or 4 other companies to the petition. So Quatford, in which he is the 50-50 shareholder, no finding of unfair prejudice, because he's running the things, no exclusion from management, then Ivy and Aldi are bound, on their analysis, to carry on running this litigation in respect to all of the companies right to the end. But that cannot be right. It's completely at odds with this court's judgment at paragraph 45, first time round. The individual companies have to be looked at separately. And we say, therefore, on a proper analysis, the Kingsford offer satisfies the criteria. It's remained open throughout the hearing before the judge and remains open yet. It doesn't have to remain open. We could have withdrawn it. It's now been open since October last year and hasn't been accepted.
Open until when? What's the current position?
It remains open.
You could withdraw it this afternoon.
Oh, we could, my lord. Absolutely we could, but that would not affect the...
I have that point.
Yeah.
I just want to know what the facts are. The facts are it's currently open, but you've given no commitment to keep it open for any longer.
We haven't given any commitment at all, my lord. We will keep it under review
Yes.
as we go along. But at the moment, it was... His Honour Judge Cooke asked whether it was open, whether it would remain open after his judgment. And at the time, I had to say, well, we'd take instruction on that. The instructions were we would just consider it. But it's remained open for however many months we are now, 13 months. No, sorry, 12 months, almost exactly 12 months. May I then turn... So that's what we say in respect to Kingsford, and therefore that's why I petition in respect to Kingsford.
There's no point taken that you didn't offer costs.
No point at all. And indeed, it would be, given the history of it, where they rushed off and got the injunction, which was then overturned, and they've also had 5 attempts, I think, to get the petition right, it would be rather rich of them to say we've got to pay their costs.
But they don't say it.
They haven't said it that way. So if I may, then I'll turn to exclusion from management. And we've dealt with the fact that there's nothing in respect to Bretton Park. There can't be a proper complaint about Quatford, because of it being a 50-50 case. The judge suggested in his judgment that if an administrator was appointed over Quatford, that would effectively give control to Ivy and Aldi and exclude Michael. Well, that is plainly wrong. An administrator comes as an independent person and doesn't give control to any director of the company. So that can be left out of account. No ability to seize control and oust him without also effectively ousting herself. and as to sales, because of course the sales misappropriation in the court's ruling. So the exclusion from management complaint can only relate to Kingsford and Riverside Stourport. The latter company is not trading, it simply holds a caravan site which it's yet to develop, that having been held up by this litigation. As regards the amendments to support Michael's alleged entitlement to participate in management, we say the judge misunderstood and misapplied the Court of Appeal judgment by which he was bound. And particularly, he failed to consider the separate questions whether an arguable express agreement or understanding for the alleged right was pleaded, and if not, whether sufficient further facts, in addition to those which were already pleaded before the Court of Appeal, were pleaded to justify inferring such an agreement. Had the judge formulated and addressed those questions properly, he would have been bound to conclude that the proposed amendments pleaded only an agreement or understanding to be inferred, as opposed to express agreement or understanding. And that's not surprising, given the concession in the Court of Appeal last time by Mr. Stockill that there was no express agreement.
Is that recorded in their judgment?
Yes, I think it is.
It is.
It is.
That there was none pleaded, not that there wasn't.
There's none pleaded and none evidence, I think was the what was said. So what was pleaded
It's 50 paragraphs.
was the amendment was pleaded at paragraph 48. We have in the supplemental bundle all the various versions of the petition.
Yes.
So if I invite you to reread paragraphs 48, 49 and 50. And it's in 50 that Mr. Stockill accepted there was no express agreement to understand that Michael would have that right, and that is the right set out, referred to in the amended pleading at paragraph 48, that submitted such an understanding was to be inferred. In my judgment, no such agreement or understanding or any form of extra restraint can properly be inferred from these facts. So, yes, my Lord, it was expressly recorded in the Court of Appeal judgment.
Thank you.
And the judge should have held that there was no pleading of sufficient new facts to support the proposed inference. A further alternative, we say the judge didn't give appropriate weight to the adverse comments in the Court of Appeal judgment regarding the sales misappropriation. If he'd done so, he would have concluded it was not arguably unfair to exclude Michael from managing any of the corporate respondents because Michael's conduct in relation to sales made him unfit to manage any company or alternatively any company with the same ownership. Before making good those submissions, can I deal in passing with there's an orphan breach of fiduciary duty contained in the amended petition at paragraph 63. If I can invite your Lordships and Ladyships to turn up to page 252. So 63 complains that the matters in 61 are in plain breach of the duties, that being the director's duties, set out above in a manner which does not require any further particularity. 61, and so his Lordship struck out subparas 1 to 16, but didn't strike out 17 to 27. But 17 to 27 all relate to partnership, have nothing to do with any of the respondent companies. They're all said to be breaches of the order made by His Honour Judge McCarhill in respect to the partnership. They were all present in the petition as it stood before the Court of Appeal last time, and the Court of Appeal said did not disclose a seriously arguable case of unfair prejudice. Now, I don't have time to run through each of them one by one, but if one looks through them, you see they're all
Sorry, are you referring now to the ones that haven't been?
the ones that haven't been struck out.
Yes, 17 to 28.
Yes, my lady.
You're saying the Court of Appeal said there's nothing in them.
They were there before the Court of Appeal, and the Court of Appeal said no seriously arguable case of unfair prejudice. 63 was there before, 64 was there, and 65 was there. So it should have been struck out, and we argued that all of what was then 36 to 65 should have been struck out. And the judge declined to do so. We've just been looking at the Court of Appeal judgment, and we've looked at 45, 47, 8, 9, and 50, and then at 52 and 53, I think we've also had we've seen as well, and then at 56 to 60, the Court of Appeal dealt with the question of Michael's removal as the Director of Sales. And in essence, what it came down to, but I invite you to read it, is that he, having misappropriated £1.25 million from sales behind the back and contrary to the other directors' wishes of that, was a clear breach of fiduciary duty, and it was unarguable for him to say that his exclusion would be unfair. As I should have said, I think I said already in paragraph 50, and apologise if I didn't, that in paragraph 50 of the judgment, the Court of Appeal said there's no entrenched rights to be involved in the management of the company, not limited to the sole control argument. Now, paragraph 38 of our skeleton argument
So do you rely on the sentence at the end of paragraph 53 of the Court of Appeal's judgment, which you referred us to before, where Justice Floyd says, apart from the attempts to change the accountants, in the case of three of the companies, there's no allegation at all which consists of conduct of affairs and companies. Is that your answer to the paragraph 63 point?
My lord, yes. Well, sorry, the Court of Appeal said there was no seriously arguable complaint of unfair prejudice at all.
Yes. And they had this pleading with those particulars.
My lord, yes. And that's in the bundle at tab 8, the supplemental bundle, the version before there. So all those particulars were there.
But they still say there's no allegation of anything which consists of the conduct of the companies in relation to those three companies, and in relation to the other two, they go on and look at the particular things which is exclusion from management.
My lord, yes. So there were allegations with respect to changing the accountants, etc.
Yes, and non-payment of tax.
Yeah, which have all been struck out, and they have been struck out. Yes. So we say nothing has changed from the end of paragraph 53 into this new petition in respect of the bits which were there. So those bits have to go. It should have gone. And indeed, given they're all allegations in respect of partnerships and none in respect of the companies, it's difficult to see any basis on which they should have been pleaded in the first place as allegations of unfairly prejudicial conduct of the companies.
Sorry, I misunderstood you. Are you saying 17 to 28 also related to the partnership?
Yes, ma'am. Sorry. As it happened, 1 to 16 did relate to the companies, but they weren't good enough. 17 to 27, I think it is, because 28 is the roll-up, each relate to the partnership, and the orders Honourable Judge McCarhill made in respect to the partnership, they all said to be breaches of that partnership order.
Okay. You say 17 to 28 should have come out anyway.
And therefore, 63 goes, because there's nothing left in 61, and it follows 64 and 65 go too.
So although the allegation in 28, the roll-up allegation is this behaviour is calculated to harm the interests of the companies and the petitioner qua shareholder, you say that's unsustainable.
It's unsustainable.
Yes.
And there will be no, once you take out 16 to 27, it refers back to nothing.
Yes.
This behaviour is nothing. So it simply doesn't work.
Before we go on, can we just go back to Riverside Starport, and we're still going to return to it. You said very briefly it's not trading and the site isn't being developed. No action has been taken, as I understand it, to remove Michael as a director. So the company is just inactive.
The company is just sitting on the site at the moment, as I understand it, but Michael has not been removed as a director. And the only action in respect of Riverside Starport has been in respect of the loans, which we'll turn to in due course. Nothing in respect of the management of Riverside Starport. Paragraph 38 of our skeleton argument, page 188 of the bundle, we set out what would be necessary to cure the fatal defect, and there was no evidence from Michael at all to support the application for permission to amend. All there was the very short witness statement of Mr. Averill, which is in the supplemental bundle at tab 11 at page 210. Where there's no condescension to the merits at all, and all one has is paragraph 6 and 7. Now, this application was made at a time before the Supreme Court had ruled or declined to grant permission to appeal from the Court of Appeal. But you'll see in 6, it says it's accepted by the petitioner's legal team that if permission is refused, there'll be some excising of allegations contained in the original petition where the petitioner claims by equitable extension strict legal position the sole right or even any right to management in the companies concerned. So it seemed to be accepted at that stage that if the Supreme Court said no permission to appeal, the claims to any right to management of the company would end up being excised.
And permission has now been refused.
Has now been refused. It's tab 15 in the supplemental bundle. And so one sees 7 is actually what the amendment is all about. And while on this witness statement, you'll see there's nothing said about the loans under the heading application to amend. No evidence in respect to that. And then you've got under the heading application to restrain the calling in of the purported intercompany loans. They're being purported at that stage. And then sets out that they feature significantly amended petition. They do. And at paragraph 11, the loans, if called in, will significantly harm the financial and overall interests of the group as a whole, and particularly borrowing companies. No reason at all submitted why the loan should be called in at present, and none is given. The reasons given in the petition, the fact that there is a threat to do so itself amounts to unfair prejudice, etc. And we'll come back, I'd highlight that to avoid having to come back to it later. We'll come back to that later on the question of additive damages, etc. Now, we have set out, and in light of the time, I'm going to have to go through this relatively quickly. Paragraphs 39 to 44 of our skeleton argument, we have set out in detail how we say that the judge went wrong and what the proper analysis should have been. I don't intend to read those out to your lordship, to your ladyship, but invite you to reread them when considering the application. We then, at paragraph 47, go on to deal with the removal of him from Kingsford in light of the sales misappropriation misappropriation from sales. And we refer at 47, we quote 47, a passage from the Court of Appeal judgment, which was said in relation to the company, the partnership appeals as to who should have conduct of the partnerships. But if it's a perfectly proper observation of paragraph 82 of the judgment. Where the Court of Appeal rejected my submission that this was obviously dishonest. And they said, it remains material that he'd removed a very large sum of money from one of the companies against the express wishes of his fellow directors and shareholders, and displayed a distorted and self-interested approach to the principles of corporate governance. And that is clearly in relation to his conduct of sales, and then it was being put into the balance as to what was going to happen in respect of the partnerships. Now, in Michael's case, of course, he says all these corporate responses are closely related. But if that's right, then the fact you've got someone taking money against, a very large sum of money against the wishes of directors in Company A is a perfect good reason for excluding them from Company B's management as well as Company A's management. The Court of Appeal have already said perfectly proper to exclude from Companies A, unarguable, so that's unfair prejudice, and we say that must apply to Company B, in this case, Kingsford. And we can illustrate this in this way. So the proposition is that conduct in relation to Company A can justify exclusion from Company A and prevent such exclusion from being unfairly prejudicial. That's what the Court of Appeal have already held. Proposition 2, in certain circumstances, that same conduct in relation to Company A can justify the exclusion of management from Company B and prevent exclusion from being unfairly prejudicial. And I give you a hypothetical case here. 2 corner shops, each a separate company, each with 3 directors and 3 shareholders of equal shareholding. One of the directors, X, is caught with his hands in the till at the shop owned by Company A. That obviously justifies his removal as a director of that Company A and would make any prejudice to his interests as a shareholder fair rather than being unfair. It's unrealistic to suggest that the fellow directors and shareholders, Y and Z, could not also remove him from Company B to prevent him doing exactly the same in respect of Company B.
Michael was left in control of the partnerships.
He was the one, yes, of Redstone. He was, yes.
Yeah. But that's the point that's taken against you, is you can't just assume that this applies to all the companies.
Well, that's a partnership, not a company.
Why does that make a difference?
Well, in my submission, it shouldn't have made a difference, my lord. But the partnerships are in the course of being wound up. So the Court of Appeal made an order the partnership should be wound up. And so that's very different from the ongoing running of the companies as live entities. These companies aren't currently subject to any form of winding up. So if he's misappropriated 1.25 million out of Company A, and that's 1/3 shareholder, disregarding the express wishes of his mother and father, his co-directors, it's perfectly right to say that we can exclude him from Company B, where it's exactly the same setup, it's just a different site. So we say it's unarguable that he can't be removed from Company B, in this case, Kingsford. And I was going to try and run a trust analogy, but I'm not sure I have time. But the beneficiaries of a trust, having found the trustee had taken money from one of the trusts of which they're beneficiaries. One can't imagine them going to court to seek the removal of the trustee in respect of another trust of which they're beneficiaries and being told, no, you can't.
It's not a very close analogy, because trustees don't have a right to manage trusts.
Oh, well, no, not necessarily, but of course the companies, it's closer than you think perhaps, because company directors are trustees of the company property.
Well, of course they are quasi-trustees of the
Yes.
company's property, but the foundation of this jurisdiction, Section 994 jurisdiction, is that the rights of participants in companies can extend beyond their strict legal rights under the articles, whereas no trustee has a right to remain a trustee.
No, that's why I said I was going to try it.
Well, Mr. Ashworth, I think we've covered this point. You've got half an hour to deal with the loans.
My lord, I'm going
So
to
shall we
turn
go
to
on
loans
to the loans?
right now, if I may.
Yes.
We say that the judge was wrong in law and principle on the facts as pleaded to hold that the equitable constraints alleged by Michael to prevent loans from being demanded, repaid or secured in accordance with their contractual terms could arguably arise. Those constraints would be illogical, unprincipled and irreconcilable with his averment that the relevant payments were interest-free loans repayable on demand. In any event, we say there's a need to, and the judge did not distinguish between Michael's interests as a shareholder of the creditor companies, Kingsford and Sales, or his interests as a shareholder of the respondent companies, the respondent debtor companies, Quatford and Riverside Starport, let alone from his interest in Far Forest, which is not part of these proceedings at all. We say on a proper analysis, calling in the loans cannot arguably prejudice his interests as a member of the creditor companies, and Ivy and Aldi would not arguably be conducting the affairs of the debtor companies by calling in the loans on behalf of the creditor companies. Where they could cause a debtor company to repay a loan made to it, something they could only currently do in respect of Riverside Starport, they would not thereby be conducting the affairs of the creditor company, but the affairs of the debtor company. So when one looks at the shareholder, the directorships now, it's only Riverside Starport where they're in a majority of directors of a debtor company. Now, this was introduced, this amendment, on the 17th of November 2020. So 7 days before the hearing before His Honour Judge Cooke. And that was in response to the letters at tab 7, which I hope have been inserted at tab 17 in October 2020, saying that we wanted the loans repaid or secured. They're at page 312 in the supplemental bundle. This wasn't, of course, the first time the question of loans had been raised, because in the August exchange of emails, the reference for which is at tab 2 in the supplemental bundle, 19 to 21, one of the questions being raised following the Court of Appeal having announced the decision but not given reasons was what was going to happen to the loans. And the response to that was the intercompany loans charges will need to be placed on Bretton Park, Hollands Park and Far Forest to secure the outstanding lending. So that was in August 2020. There wasn't at that stage any suggestion we can't do that because this is all part of Michael's interests as a minority shareholder. And the concern in October 2020 was to ensure that the debtor companies would be in a position to repay. That was a concern particularly in respect of Far Forest, given that Michael has indicated that he'd borrowed on the strength of Far Forest the £1.25 million to pay back to Sales. So you've got a loan out of Far Forest of £1.28 million by the companies. He borrows a further £1.25 million in order to pay back the money he's misappropriated.
So that has been paid back to Sales, is it?
The 1.25 has been paid back, but as Ivy sets out in her witness statement, paragraph 29, her fear is that it's been paid through, by way of raising money through Far Forest, and she gave evidence to that and that's in the bundle before you at page 220. We say this new case on loans is a pure contrivance. I've taken you to the witness statement of Mr. Averill. It doesn't contain any evidence to support this at all. There's no documentary evidence to support it at all. In fact, it's contrary to the documentary evidence that was before the court below and expressly referred to in the judgment at page 227 in paragraph 35. Where he records quite properly that they are all shown as being repayable within 12 months. If what Michael says is true, there would at least have to be some provision made for the recovery of these loans in these accounts. These accounts will no doubt have been supplied to the likes of the bank. Take the example of Quatford, for example. Half the monies lent to Quatford were in fact lent by Kingsford. There's an error in the petition suggesting that it was all lent by sales. Half was lent by Kingsford, which had been borrowed from the bank, and half lent by sales. Imagine what the bank would think if in the Kingsford accounts, the company to which it had lent, they had to say, well, this £2.5 million loan is never repayable unless the recipient agrees for it to be repaid. One would have to provide for it or impair it in some way. And we think it's necessary to look at what he says in his pleading in respect of the loans. And we want to start at paragraph 76 at page 253. And what he does in 76 through to 79 is go through each of the loans and referring to them as a cash contribution treated as a loan for tax reasons, and the loan being interest-free. It's a strange pleading because a cash contribution implies it may not actually have been a loan, but there is no assertion that the loan was a sham. And the averment that the loan was interest-free indeed confirms it was a loan. And that's the loan to Far Forest, the same in respect of 77, the loan to Bretton Park, 78, Riverside Starport, and 79 to Quatford, which itself holds Hollands Park's estate. 79 is the one which is factually incorrect because it's there that it's said the total lending of 5.3 all came from sales. In fact, 2.6 was funded by a bank loan to Kingsford and then paid over.
So 79, line 2, delete sales.
But Kingsford, yes. And we have in our schedule, in our table, we've set out what the current position of that lending is. Now, 84, the pleading is that the intercompany loans were intended to remain outstanding indefinitely. They were intended by the petition by the first two responses as investments by the lender for the benefits of the shareholders of the borrowers, as had been the case with cash contributions in respect of Marston, Woodman and Avonside, which had been made as gifts to Mercedes, Audi and Lisa, respectively. They are gifts, they were genuine gifts, and they weren't loans. Those ones. It was a clear understanding of the petitioner and the first response at the time. The loans were made, and subsequently until the recent events mentioned below, the loans would remain outstanding indefinitely. The only circumstances where repayments were intended to be made were where the parties agreed such in the pursuance of the business strategy outlined above. This understanding was shared subjectively by all three of them and would also have been the understanding of any reasonable person in their position with the knowledge of their own business, which they all had. These aren't investments because there's nothing, there's no return on the investments. And it makes, in our submission, little sense to suggest that these loans were to be treated in the same way as the gifts in respect of the other sites. So in 85, they've set up the only circumstances where repayments were intended to be made, or where the parties agreed such in pursuit of the business strategy above. And that's the business strategy at paragraph 68 and at 80 to 91. So we have a situation where the loans are only repayable if Ivy, Aldi and Michael all agree that they should be repaid. And of course, that's a remarkable situation to have, especially with respect to Far Forest, because Far Forest is owned by Michael and was never one held by any other members of the family. His case would seem to be that enforcing the loan to Far Forest would in fact be necessary to further the group strategy that he describes of acquiring other sites. They need to get the money back in to acquire another site. But it would never be in Michael's interests for Far Forest to repay the loan to it, because he's the sole owner. And since, on his case, it would only be repayable if you agreed to its repayment, it's not a loan at all. As a matter of practical reality, it's a gift. But that is not his pleaded case. And what
I think it's also said in the skeleton that if one of the companies became insolvent, the insolvency practitioner could call him a loan.
My lord, that's not part of the pleaded case. And this is something which, I'll come on to it, his lordship below added a gloss on this, which wasn't there in the pleaded case. Here we have a pleading, so the only circumstances are this. Now, of course, your lordship's right. What happens if the creditor companies face insolvency, or they have cash flow difficulties? On Michael's case, pleaded case, he can still say, I don't agree to you having this money back. I want to keep it in Far Forest. What if there were concerns about the solvency or future prospects of the debtor company of Far Forest? We know it's borrowed money. What happens if we think it's going to the wall? Ivy and Aldi, on Michael's case, simply can do nothing to get that money back. The debtor company is facing its own problems, and Michael can say, I do not agree. And that, we say, would be a complete breach of fiduciary duty by Ivy and Aldi, because they'd be preferring the interests of Far Forest, to whom they owe no duties at all, to the interests of the companies of which they are directors. And on Michael's case, he could transfer the Far Forest site away, the valuable asset which Far Forest has, to another company, making Far Forest insolvent, and Ivy and Aldi could do nothing about it at all. You have to sit back and just watch it happen. Now, the judge recognised the difficulty inherent, as your lordship, Lord Justice Nugee just has, in that being the only event which could trigger, and he added the gloss at paragraph 26 of his judgment, at page 226 in the bundle. We're right at the end, having dealt with the fact it was repayable on demand. He says, they might at the same time have a common understanding to expect to be long-term finance and not expect to be repayable without either the agreement of all, that's a pleaded case, or perhaps some other good reason for needing the money to be repaid. That is not the pleaded case, and it begs so many questions. How is it to be decided in any event if the money, there's some other good reason for needing the money to repay it? Who would decide that? Well, people who should decide it will presumably be the directors of the company, the majority directors of the company. And they have decided they want the money back. They're worried about Far Forest, they want the money back. There is some other good reason.
Have they said what the reason is for calling the loans in?
Ivy's witness statement in the supplemental bundle Sorry, first it's dealt with in the correspondence at tab 17, which I haven't got time to take through, my lord. But also Ivy's witness statement in this respect at tab 12 in the supplemental bundle deals with it at pages, there's a heading, reason of calling them loans, paragraph, page 217, and it goes the whole way through to 221. So she sets out the reasons. That obviously they're worried about Far Forest, its solvency, and they want the whole thing regularised. And what there is a calling in the Far Forest loan. In respect to the others, they want security. What they're after is that the positions be secure. So, for example, in Quatford, where Michael has sole control of it, what they've actually said is we want security granted in favour of the lending companies. And we're enjoined from even seeking that.
Is that dealt with in the same witness statement?
Sorry, in terms of
The security
my lord, sorry, it's there and in the correspondence.
which is at tab 17.
Tab 17, my lady. There's the letter of the 5th
Yes.
of October, and then there's one of the 14th of October from us, and then there's one of the 6th of November, which was never responded to, and indeed not addressed in evidence by the other side and not mentioned in their pleading.
Do you accept that qua directors of accredited companies, they have to act in what they genuinely perceive to be the best interests of those companies?
My lord, yes.
Because you're facing a suggestion that really Ivy and Aldi are simply calling in the loans out of spite, just in order to make life difficult for Michael as a reaction to the fact they've been dragged into this litigation.
My lord, this is exactly the same allegation which was made against them having presented a statutory demand for payments to 1.25 million. And the Court of Appeal on the last occasion said, no, we are not here able to second guess the best interests of the directors when they say they've exercised their best interests. And in any event, it's got to be in the interest of the company to get its assets back in. And how can it not be in the interest of the company to get its assets back in?
Well, it's not quite the same, because 1.25 million, the Court of Appeal accepted, had just been taken without any possible justification.
Yeah.
Whereas these loans were made. There's no suggestion that they
Oh,
were
no.
improperly made in the first place. And the question is whether it is in the interest for accredited companies to call them in. Are you inviting us to just conclude that they must be genuinely thought to be in the interest of accredited companies?
Well, that's the evidence. There's no contradiction to that.
Yes.
They've said, we've considered the position and we want the monies, we want the loan from Far Forest back in. And clearly that's in the best interest of the company because Michael has not said what the position of Far Forest is. He's never responded to this and said, oh, by the way, Far Forest's got bags of money, you needn't worry about it, there's no problem at all here. We have absolutely nothing from him.
Okay, so there's no responsive evidence to Ivy's evidence.
No. And no response to the letter of the 6th of November 2020. And it may be said, well, Ivy's witness evidence came in just before the hearing. Well, that's unsurprising given they only served their application on 7 days before the hearing. They didn't say, we'd like an adjournment to put in some responsive evidence. There's no response to that at all. Sorry, I just turn my back on you for a moment.
Yes.
My junior makes a valid point that I should reinforce, that it's only Far Forest we're seeking the money back. In respect to the others, we're seeking security to ensure the position of the companies.
Would you say that has to be in the interest of accredited companies?
That's fair. I mean, it can't possibly not be in the interest of the creditors. Sorry, of the companies that they're acting for.
And is it suggested that prejudices Michael Quay, shareholder of...
Well, it appears to be, yes. It appears to be suggested that any action in respect to loans prejudices Quay shareholder. And we just don't understand, for the reason we set out in our skeleton, how his interest as a creditor, as a shareholder in the creditors, could possibly be prejudiced. And how is your interest as a shareholder in the debtor companies prejudiced if all you're doing is saying, we owe you money, we're prepared to give you a charge? How does that actually affect his interests as as a shareholder in the debtor companies. And that's never been addressed.
But you have the other point, is that for the creditor to ask for security is not conduct of the affairs of the debtor
no.
company.
Right.
So it doesn't matter if it prejudices him as a shareholder of the debtor, unless he can show that there's unfairly prejudicial conduct of the affairs of the debtor.
My lord, yes. My lord, we still had quite some length in our skirts, but you have it very succinctly. I don't intend to go through it in great detail, but what is said at paragraph 48 of my learned friend's skeleton argument, at page 214, paragraph 48, it suggests we narrowly focus on the loan itself, pay no regards to the benefits which the company received by retaining the services of the recipient. Even if Michael should be treated as the recipient of the loan, rather than Far Forest, he is, of course, no longer providing any services to Sales or Kingsford. They're not receiving any benefit from retaining his services. On his case, the logical conclusion is he could have stopped working for Kingsford and Sales the week after loans to Far Forest were made, and Far Forest would be entitled to keep the loans until he decided he wanted to pay back, until he agreed to pay back. And in paragraph 49 of my learned friend's skeletons, they say the arrangement would not have been binding on creditors, but of course the creditor of the subsidiary of the debtor companies are the lending companies. So it's not binding on them. So we just don't understand how it works. But his problem is he's stuck with paragraph 85 of his pleading.
Now, Mr. Ashworth,
yes.
Would you like to spend the last few minutes on adequacy of damages in the interim injunction? Or you say it's so obvious it's not worth spending a few minutes on?
Certainly, my lord. Can I invite you then to reread our skeleton in respect of the loans where we set out, in due course, we set out in details. I haven't taken you to any of the authorities. They're all there and the references are all there. I should just quickly in respect of Quatford say, in respect of that, the judge suggested there was a threat to make it insolvent. Calling in a loan or seeking a charge in respect of a loan does not make a company insolvent. It's either solvent or insolvent. And nor would the appointment of administrator give control, as we've said. And, of course, these loans have got to be dealt with at some stage. The relief he seeks is for sale of the shares. It has to take into account the loans. The loans have to be repaid. If it's just an equitable winding up, the loans have to be repaid. If it's a forced winding up, the loans have to be repaid. As to the interim injunction being refused, we set out in writing at paragraphs 84 to 93 of our skeleton argument in our submissions, and I don't repeat those there. I make the following additional points. In paragraph 86, we say the judge completely overlooked the second stage of the American cyanamide test, and there is no attempt to engage with this in my learned friend's skeleton argument, where they deal with paragraphs 59 to 61. There is no evidence at all before the court, there was no evidence at all before the court as to the adequacy or inadequacy of damages to Michael. There was a reference in the skeleton below to a 5% interest per annum. It would cost £62,500 to finance the loan. Well, that's clearly something you can measure in damages. It turns out that's wrong. So there's a figure there that wasn't evidence, that was just referred to by my own friend in their skeleton below. If you want an injunction, you have to adduce evidence as to inadequacy of damages. I've taken you to that witness statement of Mr. Averill. That's it. There is nothing more. There is not saying I can't afford to pay this. I can't afford to repay this loan. We have nothing about Far Forest at all. Saying I simply can't afford to pay this. And if you cause you to pay this, it will, for example, cause the bank to call in the 1.25 million loan they've given me, which I've used to pay back the money to Sales. We simply don't have that evidence. So there's not the evidence there for the judge to have been able to do the assessment of adequacy of damages. And he doesn't. He doesn't touch it on it in his judgment. And indeed, no effort before the judge below, indeed no effort now. You don't have an updated position now. You could have said, here's evidence of what the current position is, and this is why you should maintain the injunction. All the judge did say is that the submission we made that Far Forest's ability to give security was doubtful. His only observation was that had not been raised in correspondence. Well, it doesn't matter, it was in the evidence. It doesn't matter if it was in correspondence, it was there in the evidence. There's really no more I need to say about the question of the injunction, which isn't already in writing. But we said that even if the judge was right to allow the amendments to the loans, which you say he plainly wasn't, he shouldn't have granted an injunction. He should have let us get on with it, even if it could have arguably been unfair prejudice, which you say it wasn't. I have run 2 minutes over my time, my lord, and I have
We can forgive that. And thank you very much, Mr. Anderson. Yes. Mr. Anderson.
May I just have a moment to set my stall?
Of course.
My Lord, there are 5 companies the subject of this petition, and there are some differences between them, and so I'm going to concentrate on one of them first of all, and take most of my time on that company, Kingsford, and after that cover the other companies where they are different. So dealing first with Kingsford, so that we don't get distracted by the wrinkles and quirks that the other companies import. If we could go to the amended petition that the judge allowed at page 253 of the bundle. After setting out the background of the respondents, Ivy and Aldi having traded since 1973, and having set out in paragraph 67 that Michael was invited into that partnership as a 1/3 member in 1990. Over the years, the partnership acquired a number of caravan sites, and some of them, most of them, are set out in paragraph 70 with the date of the acquisition. Redstone is one of them. It's true that that files separate accounts, but it's the same partners with the same shares, and to all intents and purposes, it's part of the same business. Now, Michael, having been a partner since 1990, I don't think it is contested, has participated fully in the business of the partnership since then until recent events. Kingsford, the company that I'm currently talking about, was acquired in 2003. Michael's case starts at paragraph 72 about this particular company. He says that it was only acquired as a company because that is what was for sale. They were not selling the business, they were selling the shares, and there was no conscious decision by the family suddenly to start trading via a company. That's disputed factually, but that's his case, and we're not here to try the case. Since the partners in the partnership who acquired Kingsford were partners all participating in the management of the business, and then all became shareholders in the business which they had acquired, in the same shares as they held in the partnership. And since they continued or proceeded to run Kingsford in the same way as they ran the rest of their business, the allegation that they all understood that that was how it was to be run is not a surprising allegation. I'd venture to suggest that it's not an allegation that should be too difficult to prove. If there was an understanding that it would continue to be run, that this new business, this new caravan site would be run in the same way as all the other caravan sites were run by the partnership, it won't be too difficult to persuade a court that Kingsford is a quasi-partnership. And it won't be too difficult to persuade a court that Michael has had a legitimate expectation that he would be involved in management so long as his capital was tied up in that business. Could we go to the authorities and look at Ebrahimi? Re Westbourne Galleries at tab 13. This was a partnership which was incorporated in 1958, having traded for 13 years. And its two partners became directors. Later, one of them was joined on the board by his son, and they promptly voted off the board, the other former partner. And he brought proceedings under the then equivalent of Section 994, but also claiming in the alternative a just and equitable winding up. For reasons of discretion, the judge did not grant a buyout order, and this case proceeded all the way to the House of Lords on the issue of whether there should be a just and equitable winding up. At page 284, using the bundle pagination.
I don't have bundle paginations.
I'm so sorry. The internal pagination is 376.
Yeah, thank you.
Lord Wilberforce dealt, first of all, with the authorities. And he said the leading authority was the Court of Appeal's decision in Re Yeniji Tobacco Company, a case about deadlock, but which Lord Wilberforce said was not just about deadlock companies. And the quotation that he chose is this: the circumstances are such that we ought to apply, if necessary, the analogy of the partnership law and say that this company is now in a state which could not have been contemplated by the parties when the company was formed. He then went on to review a number of the authorities. I won't trouble this court with those, but would invite you please to turn to Internal 379. And to read the paragraphs, the two paragraphs that begin, "My lords, in my opinion, these authorities."
This is the famous bit, isn't it?
It is, reread, I should say. But it repays rereading. The jurisdiction that his lordship was considering was the just and equitable winding up, and this is the origin, really, of the concept of quasi-partnership, because Parliament, in enacting that just and equitable winding up provision at the beginning of the history of the Companies Acts, had deliberately, apparently, imported into company law the circumstances in which a partnership might be ordered to be dissolved. And hence, now we readily speak of quasi-partnerships. Over the page at 380, his lordship deals with the particular circumstances of that case, saying this is an expulsion case, lettered B. And I must briefly justify the application in such cases of the just and equitable clause. And again, there's another famous passage that, again, knowing that you will have read it many times, I nevertheless invite you to read again, down to letter F.
Yes.
And then, just finally, his lordship comes to the facts of the case, and he says, it is apparent enough that a potential basis for a winding up order under the just and equitable clause existed. The appellant, after a long association in partnership, during which he had an equal share in the management, joined in the formation of the company. The inference must be indisputable that he and Mr. Nazar did so on the basis that the character of the association would, as a matter of personal relation and good faith, remain the same. Lord, those words might have been written about this case. And there is no attempt by the respondents to persuade this court that that is a hopeless factual contention that Michael is making. Their attempt is to persuade this court that it hasn't been properly pleaded. But we're only where we are on the basis of 2 or 3 of the paragraphs of the amended particulars of claim, which show that that exact basis is pleaded before you even start reading about driving forces. This was a partnership. This was what looks for all the world like a partnership asset, obviously was intended to be run as a quasi-partnership. It's self-evident, although it's denied in the defence.
Sorry, what was?
Kingsford. Just going back in the pleadings then to paragraph 46. This is part of the original particulars of claim, points of claim. This is the driving force, but not the fallacy part of it, just the driving force. Pleaded at paragraphs 46 and 47, which can be summarized as saying it's Michael, on his case, who's built up these businesses and has been responsible for their daily organization for a long time now. It then comes to paragraph 50 and following, which recount the family falling out. Of itself, this is an important allegation because it contributes to the case that Michael intends to make, that the basis of association has been lost. So we see in paragraph 54, these remain important allegations because they are allegations of conduct that is personal to Michael. And that's why it's conduct which is relevant to the management of all the businesses. It's a personal animus against him that his family has developed. It's alleged that there's a deliberate course of conduct meant to harass the petitioner, forcing him to move from Riverside Park. He now lives, he'd moved to Kingsford. My lords, he now lives at the park run by Quatford. It's not conduct that is specific to one of the businesses, it's personal to Michael. While we're here, can I just explain one point? We go on, well, we go on, just before I say that, we go on to paragraph 61. Paragraph 60 repeats really the rhetoric, if you like, of the conduct. The final sentence, conduct generated by a desire to do the petitioner down at all costs, even if it hurts them as shareholders. And then we come to 61. Now, we were hoping to keep these paragraphs in, these subparagraphs 1 to 16, until we succeeded in the Supreme Court, because we were hoping that they would be vindicated by a judgment of the Supreme Court. Those are the paragraphs that Mr. Averill was referring to as needing excision if we didn't succeed in the Supreme Court. So, following the refusal of permission in the Supreme Court, there was nothing left to excise because Judge Cooke wasn't having any of that, and he made us excise them anyway. So that explains why nothing's been done to excise anything further since permission to appeal was refused. But what we're left with is paragraph 17 to 28, which I accept, for the most part, is conduct to do with the partnership. Although it's difficult to say that paragraph 23, subparagraph 23, is specific to the partnership, or paragraph 24. In his judgment, paragraph 31, page 227, the judge concluded, it seems to me also arguable that if it is shown that a business is conducted as in effect a combined entity across several vehicles, though no doubt it is necessary to consider separately for each corporate vehicle whether its own affairs have been conducted in a way that prejudiced the interests of its own shareholders, the course of conduct that is followed across the wider business that shows an intention to treat a shareholder in a particular way may be relied on as evidence that whatever acts have been done in relation to that particular company are sufficiently serious to amount to unfair prejudice or sufficiently serious to justify relief, even if they might not have done so if they were looked at entirely separately from the rest of the combined business. For this reason, in my view, the allegations in the petition that relate to conduct in the operation of the partnership businesses are potentially relevant if, as Michael alleges, they show a determination to treat him and his interests in a prejudicial manner across the whole of the combined business. Now, I have to deal with paragraph 62 of the Court of Appeal's judgment, and I will come to that in due course. But for now, I'm simply going over the history and the case as pleaded, as we were permitted to plead it by Judge Cooke, explaining what that case is and how Judge Cooke came to allow it to be pleaded or to remain pleaded. Certainly, this, even if it is not sufficient to provide material unfair prejudice is certainly relevant to the new allegation that we make that the basis of association has been lost. So it's acquired a new relevance in any event, but I'll come to that in due course. It's relevant to that because it goes to support our case that this is not a no-fault divorce that we're seeking, that there has been bad conduct on the part of Ivy, and it is the reason why we want to be bought out or want the company to be wound up. So going back to the petition, we come to the amendments now, paragraph 60. We can start at 69, where you, and again, this is relevant to the basis of association. This overall business has always provided somewhere to live for its participants. And Michael has had to move twice since this dispute started. And we can jump ahead to paragraph 86. Another part of the basis of association is access to cash flow benefits. The partners have, from time to time, had access to luxury goods using the partnership or company money. They've always been open about it, obviously, with each other, and have always accounted for it at the end of the year. But that's a sort of loose dealing that isn't uncommon in cash-rich businesses, where money is available for somebody to buy a motor car, for example, if they want to. It goes in the books as a drawing or as a loan to them, and it's dealt with at the end of the year in the usual way. So it's pleaded that that is part of the benefit that Michael has had over the years. The judge dealt with that in paragraph 24 of his judgment. And 25. As the judge of the Birmingham Business and Property Court said, it's not unusual to see that sort of arrangement. Going back to the petition, paragraph 82. It remains the petitioner's case that he was the driving force. He was, at the very least, entitled to participate in the management of all aspects of the business. In paragraph 83, it's alleged that the corporate respondents that haven't already been dealt with above were established to hold new acquisitions as the overall business grew. The reason for the use of the corporate structure was not a desire to trade in a different way, but they intended to carry on as partners. And the last two sentences are classic pleadings of a quasi-partnership in the case of all of the companies. And it's made explicit in the final sentence. So it's in those circumstances that we come to paragraph 89. Well, I should draw your attention to 88. Really the most important paragraph in many ways, in which it is alleged that that participation in management and that existence of trust and confidence between quasi-partners was fundamental to the association. It was the basis of Michael contributing his work and efforts to these businesses and to building them up over a long period of time. And there is now an allegation in the petition that the other members of the family knew, recognised and agreed that Michael would not have devoted his energy and skills to the family business, but for that common understanding. So it's pleaded as an actual understanding, which they all shared. And it's pleaded as the basis of the association. And in light of the history that I've briefly taken the court to, it's not surprising that that allegation is made.
Can we just go back to 84? The intercompany loans were intended to remain outstanding indefinitely.
Yes.
What's the basis for saying they were intended?
That is a pleading of the state of mind, of the intentions of the parties to the loans. It's not attempting to make any, that particular sentence is not attempting to go behind it and to say why the court should conclude it was their intention. It simply records that was their intention.
Is it saying it was expressly agreed?
That sentence is not saying that, no. But if I wasn't going to deal with the loans now, and I'm sorry if I've given the impression that I was.
Come to it.
Yes.
In your own time.
Could we just go back to paragraph 88, where it says towards the end, but for that common understanding? Can you elaborate exactly what you think that common understanding?
Yes, it's the one.
Encompasses?
It's the understanding that he would not have devoted his energy and skills to the family business, but for the understanding that he was doing so on the basis of the practices and strategies described in paragraphs 80 to 87 above. It's the same as the belief and the intention mentioned in line 4.
Belief and the intention mentioned in line 4 is that he's building long-term wealth and stability for himself and young members of the family.
On the basis of the practices and strategies set out in paragraphs 80 to 87.
So that includes on the basis that he is at the very least entitled to participate in the management of all aspects of the business, does it?
Yes, because he was participating in the management when the business was formed, and when it was, in the case of Kingsford, when it was acquired, and it's a pleading that he understood, as did the rest of them, that was the basis upon which the business was being acquired and being carried on. Just as in the case of Ebrahimi. We say it's as plain as a pikestaff.
You're saying he was in fact participating?
He's been a partner since 1990, my lady. He's been, he says, running the whole show himself. But even if he's just been participating, then 13 years later, that business acquires another caravan site. Put to one side for a moment the legal entity in which they acquire it. They acquire another caravan site, and he starts to put his energy and prowess into that caravan site in the same way. And he is entitled to a third of the profits, and he does at least a third of the work. If that were it, if he was merely participating in return for a third profit share, that wouldn't be enough. But he says it was his understanding and that of the others that that was the basis of their association, that was how they always intended to carry on. That if you'd asked them in 2003, is this going to be run any differently from the partnership that we've been running for the last 13 years? Everyone would have said, don't be foolish. Of course not.
So the consequence is that he can't be removed as a director of any of the companies without all of them being wound up.
He can't be removed as a director of... He can be removed, but he should be bought out because the basis of the association has gone. Now, I don't know whether that proposition might be picked apart by reference to the fringes of this case. But I'm not talking about the fringes of the case at the moment. I'm talking about Kingsford. I'm saying that this business was acquired in 2003 on a particular basis. And if it's to be carried on with his capital in it, it must be carried on that basis. If it isn't carried on that basis, and he's now been removed as a director of Kingsford, so it isn't being, then he must be bought out, or it must be wound up. Without him being a director, but with his money in it, he's entitled to say, this was never the deal I agreed. I did not agree to invest what I've invested in a company being run only by my mother and father. Ivy and Aldi have pleaded that that's exactly what he did, that it was acquired deliberately with them as the majority shareholders so they could run it as they wanted. Well, that's the case, and that'll be tried, I hope. So in paragraph 89, we go on and plead his removal. We accept that in light of the Court of Appeal's pronouncement last year, he can't make this complaint about sales. And he has not. It appears that Lady Justice Andrews, in giving permission, appeared to think that he was attempting to maintain the allegation that his removal from sales was unfair. And in fact, he did try to, but Judge Cooke wouldn't allow it. So far from misunderstanding paragraphs 58 to 60 of the Court of Appeal's judgment, Judge Cooke gave effect to those paragraphs and did not allow us to continue to make that allegation. So it's been excised.
That just to clarify, I know you're dealing with Kingsford now. That's not. You still maintain that there is unfairly prejudicial conduct in relation to all the companies.
Yes.
Presumably based on the basis of association
and loans. Yes.
Arguments.
Yes, and loans.
Yes.
They've still got sales. Has still got his money in it.
But you expressly disclaim the allegation that his removal from sales was unfairly prejudicial conduct.
In itself.
In itself.
But his removal without buying him out is unfairly prejudicial.
You do maintain that?
Yes, we maintain that he should be bought out.
Where do you plead? But until he can... The court can't order him to be bought out under Section 994 unless an instance of unfairly prejudicial conduct of the affairs of that company is pleaded and proved against the majority shareholders. Is that not right? Well,
the court can't order it, but the other shareholders can agree it. And if they...
But we're not interested in what people can agree. We're interested in whether you have a maintainable claim in relation... I know we're getting off Kingsford, we're getting on to sales, but I'm now confused as to whether you say there was unfairly prejudicial conduct of sales in removing him as a director or not.
Well, I'm saying that in removing him as a director, there wasn't. but in keeping his capital tied into the company and not making an offer for his shares, there is.
How can it be unfairly prejudicial? If the majority shareholders are entitled, as the Court of Appeals said, justified in removing him as director, how can they be acting unfairly in saying, well, you remain a shareholder. You have all the rights of a shareholder. You don't have the rights of a director because you've been justifiably removed as director. We've done nothing wrong. What have they done wrong?
Well, I think that Lord Wilberforce in O'Neill and Phillips is the source of this complaint, and I was going to come on to that in the context of talking about sales. But of course, in O'Neill and Phillips, it was found that there was no unfair prejudice in demoting Mr. O'Neill, but there was unfair prejudice in keeping him in as keeping his investment, holding on to his investment. But in that case, he lost because he hadn't been excluded. So, sorry, in O'Neill and Phillips, there would have been prejudice if he had been excluded, but he wasn't excluded. But in this case, he has been excluded. Michael has been excluded.
But the exclusion's not unfair. You accept the exclusion's not unfair.
I do, but that doesn't stop me from submitting that the holding on to his capital is unfair.
But if there's nothing wrong with excluding him from management, I'm sorry, I think I'm repeating myself.
Yes.
Just leaving him as a shareholder, what is unfair about that? What's wrong? What's improper or contrary to the understanding about that?
Well, my lord, the basis of association has now been lost.
But that's because of his conduct, which has led to him being justifiably excluded.
No, his conduct is part of it, undoubtedly. But all the other conduct of the other parties is equally relevant, or at least at trial may be found to be equally relevant. He did not take out a loan of 1.25 million from sales in isolation. That wasn't the start of all these problems. The parties were falling out already. And he had suffered some of the conduct which I've drawn your attention to as having been pleaded before that happened.
Well, I think we'll have to come back to sales, but
yes.
I've taken you out of your course because you're really dealing with Kingsford.
Yes. So what the Court of Appeals said, let's just have a moment. In paragraph 82 of the judgment, I think Mr. Ashworth read it out already.
Not dishonest, but a serious breach of corporate governance, or words to that effect.
Yes, and the Court of Appeal also said the upshot is that both sides would appear to have had valid criticisms of the general conduct of the other. So the Court of Appeal recognised that the taking of the £1.25 million was not to be taken out of context, that it was in the context of bad conduct on both sides, or it was bad conduct in the context of bad conduct on the other side as well. The court did not make some sort of director's disqualification order and put Michael in charge of Redstone. And that speaks to what the Court of Appeal thought were his capabilities or his suitability for managing other businesses. Having committed a breach of duty in his capacity as a director of sales, it was right that he be dismissed as a director of sales, but that does not go any further than that. And the judge got this absolutely right at paragraph 34 of his judgment. And really, this characterises much of the appellant's approach to this case at this stage. They're trying to have the trial. But the judge got it right at paragraph 34. The point that Mr. Ashworth makes, that Michael deserved to be excluded from all the companies because of what he did in relation to sales may or may not be right. But the contrary is not unarguable at this stage. And unlike Mr. Ashworth's example, of course, Michael was not caught with his hand in the till. He never intended that this money would not be accounted for.
But he didn't tell anyone about it before taking it, did he?
He told the accountant about it, the company's accountant. And it was, the Court of Appeal recorded that it was not prepared to make a finding of dishonesty against him.
Right. Well, is that a convenient moment to pause, or would you like to go on for another 5 minutes, or whatever?
No, that would be a convenient moment.
Yes. All right. We'll return at 2.
You've got copies?
No, you can be out loud.
I won't be. Can we get one in here?
That's fair. Okay. Someone else has just emailed me.
Yeah.